Hi guys, I hope all is well. So in today's video we are talking about the MOI of a company and any pre-incorporation companies that can be taken by a third party. If you haven't seen topic 1 and topic 2, I'll make a playlist so that it's easier for you guys to identify the topics, and I'll call it Business Enterprise Law Exam Prep. If you haven't subscribed, please make sure you click that subscribe button. Let's get right into today's content, people. So in the corporate law reform process in South Africa, 5 key objectives were agreed upon by NEDLAC, right? So NEDLAC, remember in topic 1 I talked about NEDLAC and I said there was a transformation from the old Companies Act of 1973 all the way to now the new Companies Act of 2008. Now we're saying during that corporate law reform process there were 5 objectives that were agreed upon by NEDLAC, right? And that's simplification, we talked about this, flexibility, corporate efficiency, transparency, and predictable regulation, right? So the new Companies Act of 2008 sections of incorporation, right? So any sections that talk about the incorporation of a company showcase the simplified and flexibility objective, right? So they wanted the law of South Africa to be simplified, to not be complex, to be easily understood by people, right? And they wanted it to be very flexible. And we are saying in the new Companies Act of 2008, the sections that focus on the incorporation of companies actually showcase this principle or this objective by NEDLAC of simplification and flexibility, right? So the incorporation of a company, and I talked about this, the incorporation of a company starts, right, when the notice of incorporation is filed, right, in terms of section 13(1). So you will file, right, you file the notice, meaning fill it out, right, and then you will submit it with CIPC, right? That is when you are registering the company now. And this notice of incorporation is telling the CIPC your intention to register the company, to incorporate it, for this company to be seen as separate from you. You want it to have legal personality. And if you remember, section 19 said that from the date that the company's incorporation is registered, the company gets legal personality, meaning it is seen as separate from its entity. So now we're saying that the incorporation of a company starts when the notice of incorporation is filed in terms of section 13. So section 13 is going to give guideline on how to file the incorporation. It says as soon as you have filed it and you have submitted it with CIPC, meaning registered it and told the CIPC your intention to have the company registered, then the incorporation of the company has started, right? So in terms of section 13, the notice of incorporation must be filed together with the MOI. I said when you go and you submit that notice of incorporation, it must have company, right? And that company should be the MOI. Now, what is the MOI? The MOI is a document that can be changed from time to time. Now, that's where the objective of flexibility, right, comes into being, that this document called the MOI can be changed, amended from time to time, right? And this document sets out the rights, the duties, and responsibility of the company stakeholders. Those could be the directors, the shareholders, the board of directors, the audit committee, etc. But this MOI document is a very flexible document and can be changed as long as those changes are consistent with the provisions of the Companies Act of 2008. So you cannot now as a company go to the MOI and make changes that are inconsistent, that are contradicting provisions in the new Companies Act of 2008. It actually says that the provisions, any provisions that are inconsistent with the act, are null and void. And if I were to just recap your guys' memory from Commercial Law 1, we said that when something is null and void, it means that it cannot be fixed, it cannot be rectified. Rectified means some requirements of a contract were not met, and now you can make amendments to them and make the contract valid. But when something is null and void, it cannot be rectified, it cannot be fixed, it cannot be made valid, right? But when something is voidable, now we are saying you can rectify the contract and make it valid. When something is void, that's the end, you cannot change it. When it's voidable, you can still do something to the contract to make it valid, right? You can still rectify the contracts. Now we say if the MOI provisions are inconsistent with those of the Companies Act of 2008, those provisions in that MOI are null and void, cannot be fixed, cannot be made valid, right? So there are three types of provisions of the Act. So we talk about provisions of the Act, and we talk about provisions that can be made in the MOI itself, right? So there are three types of provisions in the Act. We have those that are unalterable. So when you say unalterable, it means you cannot change them going down, but you can change them going up, meaning the MOI cannot abolish these provisions, but they can improve them as per section 15. So section 15 says unalterable doesn't mean that you cannot change them. It just means you can improve them, you can make them better, but you cannot abolish them, you cannot remove them, right? So we have those provisions in the Act that the MOI cannot change, cannot abolish, right? So let me not use change, but let me say cannot make them cease to exist, cannot abolish them, but they can make them better, right? Improve them under section 15. And then we have those that are alterable. So the alterable provisions in the Companies Act are those that the MOI can change, right, in order to fit the business. So we said any provisions that are inconsistent with the Companies Act are null and void. Now they are saying there are different types of provisions, and the ones that will be null and void are these ones. For instance, the ones where that provision is an unalterable provision and a provision in an MOI is made to make it less, right, so to abolish it, then that provision in the MOI is null and void. I'm not sure if I'm speaking Greek, but I'll try and explain this in a better way as I go on. And then we have those that are alterable provisions. So a provision in the MOI can be made, and as much as it is contradicting what the Act is saying, if that provision in the Act is alterable, is classified as an alterable one, that is saying, as much as the Act is saying this, we are giving you permission as the directors, as the board of directors, to amend your MOI so that it fits into your business, right? So that it better helps your business achieve its goals, right? And then we have those that are default provisions. So with default, it means that once a provision is not made by the MOI, then the provision of the Act will apply. So if an MOI addresses something, then there's no need for the Act to address that thing. But if the MOI is not addressing that thing, then the provisions in the Act will come into being. They will be a default provision because the MOI failed to address them, right? And then what kind of provisions can the MOI itself have? Remember, we're talking about the Act, unalterable, alterable, and default. Now we are saying, what are the provisions that the MOI can have, all right? The MOI can obviously have provisions that alter the alterable provisions. So it can have provisions that change those provisions in the Act that are allowed to be changed, right? And then the MOI can also have provisions. Think of a provision as a clause, guys. I don't know how to better explain it. It's a clause. It's like kind of a sentence that dictates what is supposed to be done, how it's supposed to be done, right? It's a provision. And then there are specific and special conditions applicable to the company. So it could have provisions that talk about the conditions, special conditions that are applicable to the company. Say, for instance, it could say that the directors of this company need to be reappointed, or a new director needs to be appointed every 3 years. So that is special to the company, that is applicable to the company itself, right? And then it could also put provisions where you have requirements to amend the special conditions. So it's saying there are special conditions. What if you want to change the special conditions, and what requirements do you need to meet in order to be able to change the special conditions, right? We could also have provisions that prohibit the amendment of any particular provision. And you guys will see that we'll talk about ring-fenced companies and the Doctrine of Constructive Notice, etc. But in an MOI, there could also be provisions that prohibits you changing a specific provision. So say, for instance, they put the provision that directors will need to be reassigned or reappointed, or new directors need to be appointed in 3 years. And then they put a provision that says you cannot change that provision. So you are ring fencing that MOI, you are ring fencing that company, saying there is a certain provision that you cannot change. If we say you need to reappoint directors every 3 years, you cannot change that, right? So it could also have provisions that prohibits you changing the MOI itself. Right? Now, what does the MOI contain? What does it deal with exactly? Right? The MOI tells us the objects of the company, right? And this was very important in 1973 because in 1973, companies had to establish what their objects is. And when I say objects, I'll make an example just now. But companies had to established their objects and they had to stick to their objects. Hence the issue of ultra various, right? Where we're saying you're acting above your powers. Why are you acting above your powers? Because the company's MOI has established the company's objects. Now, what does this company's object means? I'll make an example. Let us say you are a fuel station, right? And in your MOI, you say that we are a company that sells fuel, right? We sell fuel. So your fuel company. Fuel company. So that is your object. That's what you say in the MOI. Now, if you go and you have a convenience store, right? So think of many fuel stations. They have convenience store, right? Convenience stores. Now, if you go and you have a convenience store under your name, now we're saying any contracts you make about the convenience store is you acting ultra various, meaning acting above your powers. Why? Because in the MOI, you put the objects of your company as selling fuel, right? So that's what object means. It tells us what exactly does your company do? What exactly does your company stand for? What exactly is the activity, the main activity of your company, right? So with the New Companies Act, really, the object does not limit you to what you can do, right? You can have the object and you could open a convenience store if you're a fuel station. With the old Companies Act, you had to stick to your objects, hence the concepts of ultra various. In the New Companies Act, even if you act above your powers, that contract is gonna be void, and you'll see because of the Turquand rule. But guys, let me not complicate this. Let's move step by step because I'm gonna confuse you. But anyways, the objects of the company tells us what the company stands for and what the mission of the company is, what the company sells, the main activities of that company. It also tells us the powers of the company so that we know when the company is acting above its powers, when it's acting ultra various. Right. It also tells us about the number of authorized shares and the type of shares that this company has. Could have ordinary shares, preference shares, treasury shares, founders shares. Yeah, different types of shares could be there. We'll talk about that just now in topic 4, where we're talking about sources of finance, right? And it also tells us about the composition of the board of directors. It tells us about the committees of board of directors, guys. Excuse me. These are independent people that are responsible for ensuring that the company is transparent, is accountable. Basically, if you think of King 4, right? So the board of directors are the people that oversee the company. They should be independent. Board of directors are not the shareholders. Board of directors should be independent. And within that board of directors, they're going to be committees, right? Some of those committees are the audit committee, risk committee, social and ethics committee, remunerations committee, nominations committee. They're going to have different types of committees, right, that look at that specific thing that the committee is focusing on. And then the MOI can also look at the election and removal of directors. So it's going to tell us, how do you elect directors? What are the requirements that we need to see in our directors, right? And then it's also going to tell us about the personal liability of directors. So say, for instance, this is important when we talk about the personal liability company, right? So mostly in a private company, the directors are not held liable for their debts. I mean, there are sections that keep them accountable. Think of piercing of the corporate veil as per section 20. But normally, right, the company is such that the directors will not be held liable for the debts of the business. However, if you have a personal liability company, you need to state this in your MOI, because with the personal liability company, we are saying you need to now keep, the directors will have personal liable, will be held personally liable for the debts of the entity, right? And then it also needs to tell us about the rights of shareholders. We could look at things like their voting rights, right? And it should also tell us about any amendments that have been made to the MOI, right? So what about rules that are made by the board of directors? So let's talk about this thing of board of directors. We have board of directors. We have directors. We have shareholders. So I like to make a distinction between these, and sometimes they interlink, but not all the time. Board of directors, normally majority should be independent people. You are independent if you do not have any interest in the company, right? And normally you are independent if a third party says you are independent, right? So the board of directors is made up of people from different fields of work, different experiences, different races, different genders that are independent of the company, and they come together to oversee the company. Then we have directors. These are the people responsible for managing the entity, but not necessarily, because you'll see in this case that we're about to do in the Giwala case, where we're saying not every director is entitled to be an executive director. We have directors that are executive directors, and we have directors that are non-executive directors. With the executive directors, we are saying you are responsible for the day-to-day running of the business. And then we have non-executive directors who are directors of the entity, can still vote, can still attend meetings. However, they are not responsible for the day-to-day running of the business, right? But they are not necessarily independent, because non-executive does not mean independent. As I said, if you are independent, it means that you do not have any interest in the entity. And irrelevant something, but maybe for interest's sake, in order for a non-executive director that was once executive to be independent, they need to wait 3 years, right? It's picking 4. Anyways, so the board of directors, those that oversee the company, can make specific rules, right, which become effective in 10 days. So the board of directors can meet and be like, okay, this is the rule that we want to make, right? And this rule will become effective in 10 days from when it was made, right? And then it will become effective from 10 days up until a time where a meeting is held and it is voted on, right? Normally it's on the next annual general meeting. And what will happen is, if this rule that was made by the board of directors is voted out, it cannot be made within 12 months, right? Unless there is a resolution that is made in advance of it becoming effective. So let's see, what kind of rule can a board of director make? Okay. Let's say a board of director makes the rule that says, in order for an executive director to be paid, as the board, we need to allow that amount to be paid to the director, right? So we need to authorize that payment. So let's say they make that rule. So that rule is going to be effective, meaning it's going to be law in that company within 10 days after it became effective, right? And we're saying, okay, it's gonna stay effective, right, applicable to the company up until the next annual general meeting, where the board of directors and non-executive people vote on it, right? If they vote that rule out that you made as the board of directors, then you cannot make the same rule within 12 months, right? Unless if you hold a meeting before, right, then a resolution is made to say, okay, we allow you to make this rule. Here you could just make the rule and it became effective without a meeting. But now we're saying, if it is denied, you need to have a meeting in advance to say, okay, you take this rule, unless you wait 12 months so that you make the rule without a meeting. That's basically what they are saying here. And then let's talk about the MOI, the document, and who it's binding on. So the MOI is binding on shareholders in the company. So the shareholders in the company are bound by the company's MOI. The shareholders and other shareholders are bound by the company's MOI. The shareholders, the company, and prescribed auditors, for example, the auditor, are also bound by the company's MOI, right? And then, guys, we're almost there. I know this is a lot. And then we talk about ring-fenced companies. So the company's name must end with ring-fenced company if the MOI contains a restrictive condition to the amendment of a company's MOI, right? That is a restrictive requirement to be met in order to make changes to the MOI. So remember when I talked about the alterable, unalterable, etc. So there are certain provisions that can be made in an MOI. And if your MOI makes a provision that has a restrictive requirement that needs to be met for you to change an MOI, then the name of your company should end with RF, which means ring-fenced, right? Or if your MOI contains a provision that prohibits changing. For the first one, we're saying there is a restrictive condition. There's a condition that you need to meet in order to change that provision. In the other one, we are saying there is a provision restricting, completely blocking you changing the MOI. If your company's MOI has such a provision that brings into existence this too, then the name of your company should end with RF, right? So this provision makes it clear that the doctrine of constructive notice does not, right, apply. So because we are saying your company's name is going to end with RF, that is telling people that there is some limit to changes in MOI that can be made, right? And as a result, the doctrine of constructive notice, though abolished by the Act, applies to ring-fenced companies, right? We'll talk about what the doctrine of constructive notice is just now, but I just want to bring it to your attention that it also applies to personal liability company. This doctrine of constructive notice is about assuming that a third party knows what's happening in the business, knows about the internal affairs of the business. So it makes sense to say that if a company is ring-fenced, meaning there's a provision in that MOI, because what does ring-fenced mean? Ring-fenced means there's a provision in the MOI that restricts you changing the MOI. And if I put RF, a person should know that there is that provision, because that's the only time you put RF. And because there is RF, we will assume that the person knows, we will assume that the third party knows about that internal affair of the entity. So the doctrine of constructive notice has been abolished by the new Act of 2008. However, it is still applicable to ring-fenced companies as well as personal liability companies. If you think about personal liabilities companies, it ends with incorporated, and that tells people that the directors are held personally liable for the debts. So if someone is dealing with the company, they should already know that fact because it's a personal liability company. They don't need to be told. The name of the company tells them, it informs them that the directors will be personally held personally liable. Right? But what is this doctrine of constructive notice? The doctrine of constructive notice states that a third party dealing with an entity knows about their internal affairs and will know when the entity is acting above their powers, meaning ultra vires. As such, a contract made, if questioned by the director, will be null and void. So remember, if you act above your powers, that contract is null and void, right? Say a director acts above their powers, that contract is going to be null and void under the doctrine of constructive notice. Why? Because we are saying under the doctrine of constructive notice, they assumed back in the day, I'm assuming in the 1973 Act, because this was abolished by the new Act of 2008. So in the 1973 Act, they assumed that all third parties dealing with the company know about the internal affairs of the company. So if you know about the internal affairs of the company, you know about their objects, what they are supposed to do, their main business activity. And if you as a person, right, under this doctrine had to deal with the company, say for instance the objective is we are selling fuel, and under the doctrine of constructive notice they will assume that you know that the MOI says they only deal with fuel. So if you go ahead and you get into a contract with that company whose object is to sell fuel, and you get into a contract of convenience store, then that contract is going to be null and void. Why? Because we assumed that you knew that this company was acting above their powers, but you still went ahead and you dealt with this company. So that contract is just going to be null and void. You can't enforce it. Right? However, under the New Companies Act, Section 19 abolished the doctrine of constructive notice. So it's saying no. We cannot assume that third parties know what's happening in the MOI. Hence, the Turquand rule came into being and the Turquand case. So the Turquand rule actually came into being through the Turquand case. I'm sorry if I'm pronouncing those names wrong. It came into being under the Turquand rule, right? So Section 19 said, no, we can't assume that third parties know what's happening in your internal affairs. So the Turquand rule came into being, as I said, and now the Turquand rule applies, and it says that third parties cannot be deemed to have known the internal affairs of the company. So if the company had to act above its powers, above its objects, we cannot assume that the third party knew they were acting above its powers. So the third party can enforce the contracts and can demand that the company performs the contract. So the contracts will not be null and void, right? So yeah, so that's the Turquand rule. Turquand rule is basically the opposite of the notice of constructive. Turquand rule is the opposite of the doctrine of constructive notice. With doctrine of constructive notice, we are saying the third party should have known the object. So if the company concludes a contract with this person, this third party, that is acting above their powers, that contract is going to be null and void, because the person should have known under the doctrine of constructive notice that this company was acting above its powers. Now, Section 19 of the New Company, that was in 1973. Now, in 2008, with the New Companies Act, we're saying, no. You can't assume that third parties know about the internal affairs of the entity. So they abolished the doctrine of constructive notice, and they bring about the Turquand rule, right, through the Turquand case. And they say third parties should not be deemed to have known the internal affairs of the company, unless if there was a matter that required them to go and check the MOI. But if there was no such matter, you can't assume that they knew the internal affairs of that entity. And as a result, that third party can enforce the contracts, even if you are acting above your powers, even if you were supposed to only sell fuel, but you ended up having a convenience store in a contract with this third party. So the third party can keep you accountable and make sure that you enforce that convenience store contract, right? And then let's talk about amending the MOI. So the company's MOI can be amended in 3 ways. It can be amended by a court order. So you go to the courts and the courts give an order that you amend the MOI. Or it could be amended by directors of shares. It could be amended through a court order, or these are the amendments that directors can make, right? They can make an amendment. So these are the board of directors. It can't be directors. Board of directors could make this amendment, right? And they could make an amendment in terms of they could make changes in the number of authorized shares, right? They could reclassify the authorized shares, those that are unissued. So say, for instance, you had 1,000 ordinary shares, ordinary shares that are authorized but not issued. Not issued means not given to people, not sold, not on the JSE. They could reclassify them from ordinary shares, for instance, to preference shares, right? And then they could also reclassify these shares. So say, they could classify unclassified shares. Let's say there was just shares. We don't know which class they fall under. They could also they could classify unclassified authorized shares, right? They could also make changes to the rights of preference shares and limitations on the rights of certain classes of shares, right? And then we also talk about, oh my goodness, I haven't eaten. I feel like vomiting. Anyways, by special resolution. So we're talking about how changes in the MOI can be made. We said by a court order, through directors, where they're making changes about things related to shares. And changes in the MOI could also be made by a special resolution of the board of directors, or it could also be made by a shareholder who owns more than 10% of the voting rights. And then let's talk about the amendment by special resolution, right? It may take a form of a new MOI, changing the name of the company or inserting new provisions. So if you want to make a new MOI, if you want to change the name of the company, if you want to insert new provisions, you need to do that through a special resolution. With special resolution, you need to have 75% or more of these voting rights agreeing with that resolution you want to take. That's what a special resolution is, which is different from a general resolution where we're saying you just need 50% going up to agree with your decision. So if you want to change the MOI and make a new MOI, if you want to change the name of the company, if you want to insert new provisions in the MOI, then you need 75% or more of the voting rights to agree with you. Now let's talk about shareholders' agreements. We're almost done. The shareholders can get into an agreement with one another. However, these should not be inconsistent with the Act. And if they are inconsistent with the Act, then they are null and void, right? I think I mentioned the Kuhala case. Oh yeah, the Kuhala case is not about that. I'm just reading agreements and I'm like, nah. The Kuhala case is about shareholders' agreements being inconsistent with the Act. Sorry, guys. Right, so the shareholders can get into an agreement with one another, and if these are inconsistent with the Act, right, or the MOI, they are void, right? But you guys should remember that there are alterable provisions in the Act. So if shareholders had to make an agreement and it was inconsistent with the Act, however, it was an alterable provision, then it's most probably not gonna be null and void. You'll see that with the Kuhala case, as long as it does not contradict much. Let me see the terms used. Oh yeah, as long as it does not have a direct conflict with the Act, then they're just gonna let it be. All right, but anyways, we'll get to that. And then pre-incorporation. So we're saying shareholders can have agreements between themselves. Normally, if they are inconsistent with the Act or the MOI, those agreements are null and void. And then we have pre-incorporation contracts. With the pre-incorporation contracts, we are saying these are contracts that a third party. Sorry guys, my mic is, oh god, okay, anyways, let me just hold it. So we're saying with pre-incorporation contracts, these are contracts that a third party could conclude on behalf of a company that does not yet exist. So say for instance you want to open a company, but you need to rent out a place where the company is going to operate, but you haven't filed the notice of incorporation, then you could get into a contract with the person leasing that property, right, as a third party, right, for a company that is not yet incorporated, meaning not yet existing, right, with the intention, and the intention you have as this party is that once the company comes into existence, they want to be bound by that contract. Now, the issue with this is that you'll be held jointly and severally liable if the company does not want to, or if there are any losses to this, right? And if the company does not ratify that contract, agree to that contract, right, in those 3 months that they are given, then you will be held liable for the contract, but you can also claim from the company whatever benefit they had gotten from that contract, right? So the board of directors have 3 months to decline or to ratify. Ratify means accept this contract, right? So the party will be jointly and severally liable for any losses in this contract, right? If declined by the company once it comes into existence, the party can claim from the company any benefits that the company got due to the contract. And under the New Companies Act of 2008, such contracts need to be written. And then we look at the 2 cases and then we are done. So we have the Grihala case, and it's talking about shareholders agreements. I'm so sorry about what I said earlier. Shareholders agreements. So shareholders agreed outside the company's MOI, right? And the court held that this was valid. This was a valid contract. And the reason this was a valid contract was because it did not have a direct conflict. So as much as it was going against what the MOI was saying, but it did not have a direct conflict with the MOI, right? So when you have direct conflicts, it means maybe you want to abolish a certain provision in the MOI. But this agreement was not like that. It was just contradicting what the MOI was saying. And the court held that such agreements are normally justifiable. So with this agreement, I remember in the case when I was reading it, in this agreement, it was talking about a normal business agreement between shareholders that is very normal in that space that they were in, right? In the business space they were in. And the court held that such agreements are actually acceptable because those are the kind of agreements that shareholders normally agree on that kind of business environment. And as much as the MOI stated otherwise, because the environment they were existing in allowed such contracts to be made between shareholders, then the court held that it was valid. And another thing that made the court decide what it decided on was because this agreement was not in a direct conflict with the MOI. So they used section 15 sub 7 to make it valid, right? But was just an agreement on how the directors of the company could be done by the shareholders. Okay, I don't know what I was saying here. Anyways, let's move on. And then we have the Turquand rule case. So Mr. Turquand was an official manager of a certain entity, right? And this entity gave a bond of 2,000 to the Royal British Bank, right, which secured the company's drawings on the current account. When the company was sued, it used the argument that it was only allowed to borrow up to an authorized amount. Okay, let me tell you what I was saying here. So with the Turquand rule, we are saying there's this company that borrowed money, right, or that had a drawings account. Think of your credit cards, right? So this company kind of had a credit card with this other company where it could draw money from that current account without them having money in it, right? And this Royal British Bank gave them a bond. Okay, so this company gave a 2,000 bond to the Royal British as security for the drawings account that they had, right? And then now we're saying when the company was being sued, its argument was that it's only allowed to borrow up to an authorized amount, meaning the company was now not able to pay off this bond, because with bonds you need to make certain payments. Now when the company was sued to have payment by the British company, it wanted to avoid payment by making the argument that in its MOI there is a provision that says it can only borrow up to a certain amount. Now the court held that the bond was valid, right? So the contract between the two parties was valid, because as much as the bank should have been deemed to have known about the provision, right, it did not know about the internal decision of the exact amount. When a bank borrows you money, they should do some form of research, right? That is what is required, because with the Turquand rule, we're not saying you are not just going to be deemed to not have known. If there is a provision, right, that, for instance, the Credit Act, right, requires you to check the credit worthiness of your client. Amid that, the company, this bank, amid the credit checks, they should have seen that the company's MOI allows the company to only borrow an authorized amount, right? So the court is not going against that. Yes, the company should have known, because they should have taken necessary steps as per the Credit Act to know how much this company can borrow. But in that MOI, it said up to an authorized amount, and the court used that argument to say the MOI said up to an authorized amount, but it was an internal decision as to what exactly is an authorized amount. And the Royal Bank, how should the Royal Bank have known the internal decisions of the entity? Unless in the MOI it had said the exact amount, would we have said that the Royal Bank should have known this. But the Royal Bank did not know this. They just knew you had to borrow up to an authorized amount. The decision as to the exact amount was an internal decision, and we are saying third parties have nothing to do with the internal decisions of the entity. They shouldn't be deemed to know what happens indoors, right? So there is an indoor rule that the company's affairs are the company's business. So a third party is not deemed to have known the internal affairs of the entity. So guys, that is topic 3. Thank you so much for staying till the end. If you haven't subscribed, please make sure you click that subscribe button. Bye guys.